قسمت کھلے گی میری، کبھی تو میرا سلام ہوگا، کیے ہی جاؤں غرض مطلب، ملے گا جب تک نہ دل کا مطلب، کیے ہی جاؤں غرض مطلب، ملے گا جب تک نہ دل کا مطلب، نہ شام مطلب کی صبح ہوگی، نئے فسانہ تمام ہوگا، در نبی پہ پڑا رہوں گا، پڑے ہی رہنے سے کام ہوگا۔
ماشاءاللہ سبحان اللہ۔ میں حال میں موجود تمام پارٹیسپینٹ کو دل کی تھا گرہیوں سے ویلکم بھی کہتا ہوں، اور اب مزید میں اپنے صدر محترم جناب جواد خالد صاحب سے ریکویسٹ کروں گا کہ وہ آگے کے جو لیکچر سیریز ہے اس کے بارے میں، اور جو آئندہ ہم ایک PDLR کے اوپر ایک پروگرام کرانا چاہ رہے ہیں، اس کے بارے میں آپ کو چند منٹ کے لیے جو ہے وہ انفارمیشن بھی دیں گے اور ڈسکس کریں گے کہ ان پروگرام کو کیسے کرنا ہے اور ہم اس کے لیے آپ کو کیا سروس دے سکتے ہیں اور آپ نے کیا کرنا ہے۔ میں آپ کے سامنے ملک جواد خالد صاحب کو دعوت دیتا ہوں کہ وہ آ کے
اعوذ باللہ من الشیطان الرجیم، بسم اللہ الرحمن الرحیم، اللہم صلی علی سیدنا و مولانا محمد و علی آل سیدنا و مولانا محمد وبارک وسلم صلی علیہ۔ ہمارے آج کے چیف گیسٹ، ہمارے آج کے ٹیچر آغا محمد علی صاحب، اور اس لیکچر سیریز کے روح رواں چودھری عمران افراسیاب صاحب، باقی آپ تمام جو پارٹیسپینٹ اس وقت میرے سامنے موجود ہیں، آپ سب کو السلام علیکم ورحمۃ اللہ وبرکاتہ۔ میں اپنے آپ کو بڑا خوش نصیب سمجھتا ہوں کہ مجھے ایک ایسی بار ایسوسیشن کا پریزیڈنٹ بننے کا اتفاق ہوا، موقع ملا کہ جس میں گزشتہ کئی سالوں سے اپنے نوجوان وکلاء کی گرومنگ کے لیے اور ہم جیسے جو گروم یا سیزن لائرز ہیں ان کو پالش کرنے کے لیے لیکچرز کا سلسلہ جاری ہوا ہے، لیکن لاسٹ پارٹی نے مرزا انور بیگ اکیڈمی بنا کر ایک نئی روایت کو جنم دیا ہے، کیونکہ پاکستان میں اس وقت دو جوڈیشل اکیڈمیز تھیں، ایک تو فیڈرل جوڈیشل اکیڈمی جس میں پورے پاکستان سے احباب آتے تھے اور وہاں پر اپنے آپ کو گروم کرتے اور جوڈیشل آفیسر زیادہ جاتے ہوتے تھے۔ ہماری طرف سے جو ریپرزینٹیٹیو رہے ہیں انہوں نے اپنی طرف سے کوشش کر کے وہاں پہ کچھ لیکچرز کا اہتمام کروایا، اور دوسری جو جوڈیشل اکیڈمی ہے وہ تھی پنجاب جوڈیشل اکیڈمی، جو ہمارے پنجاب کے جوڈیشل آفیسرز تھے ان کے لیے لاہور میں تھی۔ وہاں پہ لاہور کے وکلاء کو ایک دو دفعہ ضرور موقع ملا ہے، لیکن اس کے علاوہ باقی کسی بار کو یہ موقع نہیں ملا۔ مرزا انور بیگ اکیڈمی کا قیام در حقیقت ان دونوں جوڈیشل اکیڈمیز کو دیکھتے ہوئے اپنی لائرز کمیونٹی کو کنٹینیوسلی ان کو گروم کرنا، ان کے فیوچر کو برائٹ کرنا، اور بہت سارے وہ کنسیپٹس جو کنفیوژن کا شکار ہوتے ہیں یا جن کے بارے میں ہم لوگوں کو آگاہی نہیں ہوتی اور جب کورٹ میں جاتے ہیں تو وہاں پہ پریشانی ہوتی ہے، اس کو دور کرنا، اور اپنے ایڈوکیٹس کو چاہے وہ ینگ ہیں یا وہ میڈیوکر जो सीनियर लॉयर्स हैं उन तक प्रॉपरली अपनी सर्विसेज प्रोवाइड करना था, और वो सर्विसेज लेक्चर्स की सीरीज़ के सिलसिले में था। इस सिलसिले में मैं जो कमेटी बनी हुई थी हमारे मिर्ज़ा अनवर वे की, उनमें 5 बड़े नाम थे जिनको उस कमेटी का हिस्सा बनाया गया। जो सीनियर मोस्ट इसको हेड करते थे वो हमारे शेख जमीर साहब हैं, फिर उस वक़्त के प्रेसिडेंट तमीर इकबाल साहब उसके मेंबर थे। तीसरे नंबर के ऊपर हमारे सिविल साइड के बहुत ही अच्छे एडवोकेट, बहुत सीनियर लॉयर्स, आपने उनको सुना भी है, मोहम्मद इलियास शेख साहब थे। चौथे नंबर के ऊपर हमारे आगा मोहम्मद अली साहब जिनका आज आप लेक्चर सुन रहे हैं, और इनमें सबसे यंग लेकिन सबसे एनर्जेटिक और सबसे ज़्यादा एक्टिव पार्टिसिपेंट जो अभी ये सारा प्लान जो बना कर भी दिया था, ये हमारे बैरिस्टर चौधरी इमरान अफरासियाब साहब थे। ये 5 अफराद के ऊपर मुश्तमिल वो कमेटी है, और प्रेसिडेंट हाई कोर्ट बार एसोसिएशन उनके कोऑर्डिनेटर की हैसियत से होते हैं। और फिर मैंने अपनी उस कोऑर्डिनेशन के हवाले से सेक्रेटरी साहब को, बाकी अपनी जो एग्जीक्यूटिव बॉडी के एडिशनल सेक्रेटरी साहबा, जॉइंट सेक्रेटरी साहबा और यासर गुजर साहब जैसे आपके सामने भी मौजूद हैं, इनको मैंने ये कहा था कि आप इस हिस्से को लेकर आगे चलें। अब फ्यूचर, अभी तो ये जो सीरीज़ चल रही है आप तक इनका सारों का पैगाम पहुँच चुका हुआ है। इंशाअल्लाह फ्यूचर में इंशाअल्लाह ताअला अज़ीज़, हम पहले भी मैं जिक्र कर चुका हूँ, फिर अब जिक्र कर रहा हूँ। थोड़ी देर पहले यहाँ पर बैठे हुए इन दोनों अहबाब से यही बात कर रहा था कि फ्यूचर बेसिकली मेडिएशन का आ रहा है, और इस्लामाबाद में तो खैर से अब उन्होंने जारी कर दिया, शुरू कर दिया हुआ है। तो इसके ऊपर हम लोगों ने अपने लेक्चर्स की सीरीज़ रखना चाह रहे हैं। उसके लिए टाइम फ्रेम हमारा ज़रूरी होगा, हम इस बारे में कोई लेकर चलना चाहेंगे और लेके आना चाहेंगे। और फिर उसके लेक्चर्स के लिए हमारी कोशिश होगी कि सुप्रीम कोर्ट के रिटायर्ड जजेस, हाई कोर्ट के रिटायर्ड जजेस और हाजिर सर्विस जजेस भी जो मौजूद हैं वो आए और यहाँ पर लेक्चर दें। इसके साथ साथ जो बड़े नाम हैं, मैंने रिक्वेस्ट किया है आगा मोहम्मद अली साहब से भी और इमरान अफरासियाब साहब से, बाकी दोस्तों से भी इंशाअल्लाह बात करूँगा इस सिलसिले में, कि चाहे वो सूफी अहमद साहब है, ख्वाजा हारिस साहब है, या सुलेमान अकरम राजा वगैरह, या जो बड़े नाम हैं हमारी इस कम्युनिटी के। कॉर्पोरेट साइड के ऊपर इस वक्त जो हमारे सुप्रीम कोर्ट के प्रेसिडेंट है शहजाद शौकत साहब, वो बहुत अच्छा नाम है। मतलब ऐसे नामों की हमारी कोशिश होगी कि वो यहाँ पर हम लेकर आएँ आपके पास और आप उनसे मुस्तफ़ीद हों। आज जिस शख्सियत अब हमने इनवाइट किया है और जो आपके सामने लेक्चर डिलीवर कर रहे हैं, उनके वालिद गिरामी आगा अजीज़ अहमद खान साहब मेंबर पंजाब बार कौंसिल रहे, और रावलपिंडी नहीं पंजाब बल्कि पाकिस्तान की हिस्ट्री के बहुत बड़े एडवोकेट थे, वो बहुत बड़ा नाम था। और उनके फर्जान आगा मोहम्मद अली साहब जस्टिस की हैसियत से जाकर बेंच में भी बैठे, उन्होंने वहाँ पर भी काम किया, और इंतहाई इज्जत की निगाह से देखे जाने वाले हमारे ये एडवोकेट भाई हैं और ट्रू प्रोफेशनल हैं। और आज जो टॉपिक भी इनको दिया गया हुआ है वो टॉपिक ऐसा है कि जिसके बारे में आजकल मैक्सिमम आप जब कोर्ट्स में अपीयर होते हैं, कॉन्स्टिट्यूशनल पिटीशन लेकर जब जाते हैं, तो आपसे पहला क्वेश्चन यही किया जाता है कि आप कौन सी कॉन्स्टिट्यूशनल जुरिस्डिक्शन में आए हैं, रिट जुरिस्डिक्शन में आए हैं। मुश्किल सब्जेक्ट है, लेकिन मैं समझता हूँ कि आगा मोहम्मद अली साहब इसको बहुत आसानी के साथ आप तक पहुँचाएंगे, और मैं बहुत खुश हूँ माशाल्लाह आपकी शिरकत बढ़ती जा रही है। मैंने थोड़ा सा टाइम ज़्यादा इसलिए लिया कि हमारी बच्चियों ने आना था पिंडी से, लाइट ना होने की वजह से लेक्चर लेट हुआ, तो इनको थोड़ा सा लेट टाइम बताया गया था। अब ये आ चुकी है, लिहाजा अब मैं आपके और आगा मोहम्मद अली के साहब के दरमियान ज़्यादा हायल नहीं होगा। अब आप तमाम के सामने हमारा फ्यूचर का तो है ही है, मौजूदा इस वक्त प्रेजेंट का स्टार मिस्टर आगा मोहम्मद अली। सब प्लीज तशरीफ लाइएगा, बेटा इनको वेलकम करें प्रॉपर्ली।
Honorable President, High Court Bar Association, Secretary High Court Bar Association, Joint Secretary, Office Bearers, members of Executive Committee, respected members, brothers and sisters, Assalamu Alaikum. I am overwhelmed by the kind words of worthy President and the Secretary. I feel deeply honored to stand here today and address this prestigious gathering. On on the topic assigned to me, and it is also a great honor for me to address in Mirza Anwar Beg's Academy. Mirza Anwar Beg Sahab was my senior, and I learned a lot from him. Unfortunately, I only worked with him for 2 years before he passed away. I was directed by my father to work with him for 5 years, and don't expect a single penny, just work there. So the topic that has been assigned to me is types of writs, parties to writ petition, prayer, grounds, court fee, and procedure. So I start my topic with what writ jurisdiction is. This is the jurisdiction exercised by the superior courts and has a direct bearing on well-being of the society. This jurisdiction is very vast and is based on age-old principle. There is no wrong on the face of this earth which cannot be redressed under the constitutional jurisdiction of the High Court. Constitutional jurisdiction of High Court means the jurisdiction conferred or which vests with the High Courts under the Constitution. The Constitution, as we all know, is an act of extraordinary legislation by which people establish the structure and mechanism of their government, and in which they prescribe fundamental rights and rules to regulate the motion of several parts. Constitution of Pakistan, like any other constitution, determines the most desirable way of life of people of Pakistan and creates a government, organizes the government by creating the three principal organs of the state, that is the legislature, the executive and the judiciary. And it broadly defines their powers and duties, creates written boundaries for each one of them to severe within certain limits. Now, before coming to the type of writs, we need to understand what writ means, and very brief history I'll be giving as to how it evolved and developed into modern writs that we have today. Writ means a written order by superior court commanding the party to whom it is addressed to perform or cease to perform a specified act. Judicial Dictionary of Words and Phrases by Stroud defines it as a writ is a process by which civil proceedings in the High Court are generally commenced. These are issued in the name of reigning monarch for the doing or for not doing something. In concise Oxford Dictionary, the writ is defined as inter alia as form of written command in the name of sovereign, state or court issued to an official or other person directing him to act or abstain from doing something. The practice of issuing writs commenced in the 1st century of the normal rule in England in different primitive forms. With the passage of time, the English legal system was refined further, and for dispensation of justice, judges were appointed by the king himself, and they collectively were known as the King's Bench Division. Judges in the King Bench used to discharge the duties of the king in judicial matters and only served at his pleasure. Further evolution of the judicial system led to the birth of Court of Chancery, which was the first court empowered to issue writs independently of the crown. The Judicature Act of 1873 abolished the Court of Chancery and other courts and consolidated superior courts which exercise jurisdiction on the issuance of writs. In the Indo-Pak subcontinent, the presidency courts in Calcutta, Madras and Bombay were established by the Indian High Court Act 1862. The High Courts continued to exercise the power to issue prerogative writs within the limits of their respective original jurisdiction. After creation of Pakistan and until we had our first constitution in 1956, Pakistan was governed by Government of India Act 1935. In the said act, originally, there was no provision conferring power on the High Court to issue writ. It was in 1954 that a new section 233A was inserted in Government of India Act 1935, which for the first time vested high courts in Pakistan with power to issue writs to any person or authority, including government. It was for the first time names of the 5 writs that we have today was given. Section 2233A of the Indian Government of India Act 1935 read as Every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government, within whose territories writs, including writs of the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any one of them. Pakistan had its first constitution in 1956, Part 9 of it earmarked for judiciary. Article 170 dealt with powers of High Court to issue certain writs. Latin names of various writs called as prohibition, mandamus, certiorari, habeas corpus, and quo warranto were given under this article. In January 1962, the Cabinet finally approved the text of the new constitution, comprising of 250 articles in 12 parts. These Latin names of the writs were dispensed with in the Constitution of 1962 on recommendation of Mr. Manzoor Qadir, advocate, eminent lawyer of Pakistan, and his services were, if anyone is interested to read Justice Fazal Karim's law on judicial review of public actions, were appreciated in the said book. Then we had the Constitution of 1973, Constitution of Islamic Republic of Pakistan 1973, which provided constitutional remedies to protect fundamental rights. Part 2, Chapter 1 deals with fundamental rights of a person. This part is also called Heart of the Constitution, which provides right to life, liberty, equality before law, freedom of speech and expression, liberty of thought, belief and worship, culture and educational right, fair trial, etc. On account of infringement of fundamental rights, a writ can be filed in the High Court or Supreme Court, provided there is no other remedy available under the law. Words writ or filing of writ is not used in our constitution. Instead, words like application by an aggrieved person or by any person is used. Article 199 of the Constitution confers wide powers of judicial review on the provincial high courts in Pakistan. Now, as compared to powers of Supreme Court under Article 184(3) of the Constitution, High Court has wider and varied powers to issue certain writs. These powers cover more areas than a mere enforcement of fundamental rights. It is clear from the language of Article 199 that jurisdiction of High Court is discretionary and is exercised by observing the limitations laid down in the Article 199 itself and on the principles and precedents which, though not provided in the Article 199, are otherwise well recognized and practiced on account of various precedents. Under Article 199, the executive, judicial and quasi-judicial orders of a person, as defined in Article 199(5), can be challenged on the ground of being violative of any law or rules, etc. On the other hand, under Article 184(3) of the Constitution, the Supreme Court only interferes in cases of violation of fundamental rights which are of public importance, whereas there is no such restriction or condition provided under Article 199. This means that High Court can take cognizance of a case which discloses violation of any fundamental rights irrespective of whether or not it contains an element of public importance. If any reference can be needed, it can be given to PLD 2012 Supreme Court 224 and I.A. Sherwani's case 1991 SCMR page 1041, which defines various jurisdictions. The powers can be exercised by the High Court and Supreme Court under what circumstances. Now, the High Court has no suo motu power like Supreme Court. This practice has been discouraged in recent judgments and it has been termed as judicial overreach, which should not be exercised by High Court unless somebody brings the case before the High Court. The powers of High Court in Pakistan are salutary check on the mischief or arbitrary use of the powers of government functionaries or public office holders. These are extraordinary powers known as extraordinary measures. These powers are parameters for different powers by the High Court exercises, unlike powers exercised by High Court under CRPC or Civil Procedure Code. Actions of public functionaries are subject to judicial review. Judicial review is a process under which executive, legislative and administrative actions are subject to review by the judiciary. A court with authority of judicial review may invalidate laws, acts, and government actions that are incompatible or encroach upon constitutional prohibition. An executive decision may be invalidated for being unlawful, or statute may be invalidated for violating the terms of a constitution. Judicial review is a doctrine according to which courts are entitled in the exercise of the judicial power of the state to examine and decide two types of questions. A. Of the constitutional validity of any law, be it a result of primary and or subordinate legislation, or the constitutional validity of lawfulness of decision, action, or inaction of a person or body in relation to the exercise of public functions. This power includes power to decide and power to interpret laws. The term judicial review has not been used in the Constitution of India, neither in Constitution of Pakistan nor in Constitution of America. It has been used in English legislature instruments like Civil Procedure Code Amendment number 4, Rules 2000. Judicial review is simply defined as power of the court to see the public powers are lawfully exercised. Now, coming to the types of writs, there are 5 types of writs which can be issued by high courts of the provinces in Pakistan. The clause 1 of this article is of extreme importance. It puts some restrictions on the powers of high court itself. It reads, jurisdiction of high court, subclause 1, subject to the constitution of a high court, may, it is satisfied that no other adequate remedy is provided by law. आगे A, B, C आ जाते हैं. अब सर जो subject to the constitution है, it imposes certain restrictions on the powers of high court itself, and high court will not issue writ. For example, no writ can be issued to the president or governor, or if there is bar contained in Article 212, that matter cannot be decided by the High Court and no writ can be issued, because special tribunals are set for the purpose to examine terms and conditions of service of civil servants. Then there is limitation, for example, in 245, Article 245, where armed forces are in action in aid of civil powers, or Article 233 when emergency is imposed. And then there is a restriction under Article 198 as well, which empowers the High Court to issue writs only within the territorial jurisdiction for which it is meant for. The jurisdiction of High Court is subject to Constitution only. It is not subject to ordinary statute or enacted law. So a distinction has to be made between the constitutional jurisdiction of High Court and statutory jurisdiction, which other courts exercises, including the High Court, but only when it is dealing with the matters arising out of Civil Procedure Code, Criminal Procedure Code, or other jurisdictions. This means that constitutional jurisdiction of High Court cannot be curtailed through any other statute except the Constitution itself. Now the second thing this subclause says, subject to Constitution, the High Court may, word may is used in this. May gives a discretion to the court, where the court deems fit and proper in certain circumstances it will issue writ, otherwise not. If word shall would have been used, it would have been made it mandatory to issue the writ. So consciously the framer of the constitutions have used word may. Element of discretion has been left with the court. For example, if there is a case which is hit by laches, I'll be explaining the laches as well. Laches, but person has a clear right, or there is gross violation of law, then irrespective of the laches or person invoking the jurisdiction of court who has come to the court quite late, court can still issue the writ. Now the third thing in this subclause is where no other adequate remedy is available. The jurisdiction is discretionary, which High Court may exercise if it is satisfied that no other adequate remedy is available. Word adequate has been used, not where other remedy is available. At times the remedies are available, but if they are not efficacious or not adequate or will consume some time, then the High Court, instead of directing a party to approach some other forum, can issue the writ in spite of availability of alternate remedy. That's why word adequate has been used. There are some judgments on the point where in appropriate cases the court, instead of sending a party to the civil court, can issue a writ because the civil courts normally take too much time. But the test is that only in exceptional cases this jurisdiction can be exercised. Now, there are two clauses, A and B. In clause A, it is further subdivided into Roman 1 and 2. So, in Roman 1 and 2, there are three types of writs are covered. These are mandamus, prohibition, and certiorari. For these three types of writs, there has to be an aggrieved person who is injuriously affected to come to the court with an application, with a request to issue the writ. So the aggrieved party, when the word aggrieved party is used, it means the party whose rights are infringed. And the right is not required to be strict juristic sense. The Supreme Court, way back in the year 1969, in the case of Fazaldeen versus Lahore Improvement Trust, PLD 1969 Supreme Court 223 settled the criteria, and it was held that it is enough for the applicant to disclose that he had a personal interest in the performance of a legal duty, which if not performed or performed in a manner not permitted by law would result in loss of some personal benefit or advantage. Now coming to the writs, first is the writ of mandamus and prohibition. These two are covered under Article 199(1), Roman 1. Mandamus means we command, and prohibition means to stop or to forbid. Now, the relevant provision of the article reads, subject to the Constitution, a High Court may, if it is satisfied that no other adequate remedy is provided by law, A, on the application of any aggrieved party, make an order directing a person performing within the territorial jurisdiction of the court functions in connection with the affairs of the Federation, a province, or a local authority to refrain from doing anything he is not permitted by law to do, or to do anything he is required by law to do. और फिर इसके आगे आ जाए. The first part of Article 199(1)(a) Roman 1 confers jurisdiction upon the High Court to make an order directing a person performing functions in connection with affairs of the Federation, a province, or a local authority to refrain from doing anything he is not permitted by law to do. This is a writ or order of prohibition, commonly known as writ of prohibition. The second part relates to inaction. It confers jurisdiction upon the High Court to make an order directing a person to do something he is required by law to do. This writ or order is commonly known as mandamus. Direction is passed to a person in terms of clause 5 to do something which he is required by law to do. That person and all related officials must be impleaded as a party in the writ petition in accordance with section 79 and 80 of Civil Procedure Code, because in writ procedure is followed is that of a Civil Procedure Code. The first judgment on the point is that PLD 1970 Supreme Court page 1. The procedure provided in Civil Procedure Code is followed. So when you implead a party as a respondent, you have to implead the government or the concerned officer. The government is impleaded in view of section 79 and 80 of the Civil Procedure Code, that is Federation of Pakistan through Secretary of the concerned ministry. Section 80 reads, first I'll read 79, suits by or against government. In a suit by or against government, the authority to be named as plaintiff or defendant, as the case may be, shall be in the case of a suit by or against the federal government, Pakistan. B, in the case of a suit by or against provincial government, the province, and a suit may be instituted against, this section 80, a suit may be instituted against government or against public officer in respect of any act pertaining to act done by the public officer in his official capacity after expiration of 2 months next after the notice in writing has been delivered or left to the office. In the case of a suit against federal government, a secretary to the government. B, in the case of a suit against provincial government other than a suit relating to the affairs of railway, the secretary to the government or chairman, as the case may be. In other suits against courts, it's not relevant. So when you implead a party, you have to implead the federal government or the provincial government, as the case may be, through secretary of the concerned ministry and other officers whose acts are being complained. These ought to be impleaded as a party to the writ petition as respondents. and if it is required, then private persons can also be impeded. Now, after impeding the party, the territorial jurisdiction, you have to see that in terms of Article 199, which High Court is to be knocked at for getting the relief. The person to whom the writ is to be issued, respondents are important. They must be the persons working within the territorial jurisdiction of the High Court. Respective High Courts where the person works and relevant benches. In Punjab, we have benches in Rawalpindi, Multan, and Bahawalpur, and the principal seat at Lahore. So you have to examine which court is to be addressed with the complaint. And the benches were constituted through Lahore High Court Establishment of Benches Rules 1981. Now coming back to the topic of mandamus, mandamus literally means command. It differs from the writs of prohibition and certiorari as it demands some activity on the part of a body or person to whom it is addressed to do or to perform a public duty. In other words, mandamus is command directed to state officer of or inferior court requiring performance of a public duty specified therein. Mandamus is a high prerogative writ of most extensive remedial nature and is form of a command issued from the High Court directing any person or subordinate court directing to do a particular act, and can be issued in cases where, although there is an alternative remedy, yet such mode of redress is less convenient, beneficial, and effective, or would result in loss of time. Then the person can come to the court with a writ of mandamus seeking a direction from the court that such and such person is not doing an act which is required by law to do. Kindly issue a direction to that person to perform that act. That has to be under the law. Then the petitioner must demonstrate, bringing such writ, that he has a clear right. The standards for issuing such writs were settled in the case of the State versus Merajuddin, way back in 1959, PLE 1959, Supreme Court, page 147. The case was under Article 170 of the Constitution of 1956. It was held that mandamus cannot be issued unless the petitioner shows that he has the right to compel the performance of some duty cast upon the other party. Thus, this writ can only be issued only if two basic requirements are fulfilled. A, the person has a legal right to perform of a legal duty of public nature, and B, the authority against whom the writ is issued has a legal duty to perform its obligation. The main purpose of mandamus is to remedy defects of justice. It mostly lies in the cases where there is specific right but no specific legal remedy for enforcing such right. Generally, it is not available in anticipation of any injury except when the petitioner is likely to be affected by an official act in contravention of a statutory duty or where an illegal unconstitutional order is made. The grant of mandamus is therefore an equitable remedy, the exercise of which is governed by well-settled principles settled by the courts. Now, the mandamus being a discretionary remedy, the application for it must be made in good faith and not for achieving some hidden motive or indirect purpose. It is also issued where delay in performance of a duty amounts to not doing something. For example, there is no refusal but there is delay, then you can always come with a writ of mandamus. Recording statement under section 154 CRPC and to proceed in accordance with law is one such example where the person can come and seek a direction that a cognizable offence is made out. The police is not registering the case, kindly pass a direction to register the case, which is right to do so. And then it is for the police to investigate. Now, acquiescence or silence for some time cannot be a bar to issue writ of mandamus, provided the petitioner has a clear right which is being denied by some functionary of the state. Mandamus cannot be issued to enforce a contractual obligation. The only exception is where the facts are admitted or there are documents which do not require recording of evidence and a clear case is made out. Similarly, no direction can be issued to the legislature to legislate a particular law. This is based on principle of independence of legislature and arises directly from the doctrine of trichotomy of power. The second is prohibition, which means to stop or forbid. The Constitution commands that no judicial or quasi-judicial authority can exceed its jurisdiction. It can only be exercised by a person invoking the jurisdiction. He has to be an aggrieved person. A writ of prohibition lies to prevent inferior tribunal or court or authority from exceeding its jurisdiction or even from assuming jurisdiction which does not vest in it. It is also known as preventive remedy that can be granted only when legal proceedings are pending before the court or tribunal, and if the case is finally disposed of and decision is given by such subordinate authority, writ of certiorari will lie as a curative remedy to quash the decision. The examples are when a subordinate court or tribunal takes up hearing of a matter over which it has no jurisdiction, the person against whom the proceedings are taken can move the superior court for issuance of writ of prohibition, and an order will be issued forbidding the inferior court from continuing the proceedings. Judicial discipline of highest order has to be exercised while issuing such writs. The basic distinction between the mandamus and prohibition is the writ of prohibition differs from writ of mandamus in that while mandamus commands activity, prohibition commands inactivity. And the basic difference between prohibition and certiorari is writ of prohibition lies during pendency of the proceedings, whereas certiorari lies when act has been done and it is subject to final determination of High Court. So two writs have been common. What is mandamus? Where the person is not performing a duty, you go and request the court that kindly direct him to perform certain duty. And prohibition is a writ where you go to the court and ask that such and such person, as defined in clause 5, I'll be coming to that, is doing something which he is not required by law to do, kindly stop him. So this is the basic difference. Now the third type of writ is the most important, which every day we see that certain questions are put by the bench. What type of writ you have brought? This is writ of certiorari, mostly filed in the High Court, which literally means to be certified. Through this writ, the High Court can declare any act of government functionary or any order or decision of court as without jurisdiction, void, illegal, and having no legal effect. It is a check to see if the courts observe the law and following it, or a government is acting in accordance with law. For example, a notification is issued by the government. Anyone aggrieved and affected through said notification may invoke the jurisdiction of High Court, challenging the notification on the ground that it is being ultra-vires or illegal to the basic statute or rules. So such notification cannot be made and it may kindly be struck down. So this could also be covered under the writ of certiorari. Then the questioning of FIR is also covered in this, that FIR has been registered without any lawful authority. So first we read the relevant provision which deals with writ of certiorari, and then I'll be explaining it further. Article 199(1)(a)(2) of the Constitution deals with this. It says, subject to the Constitution, a High Court may, if it is satisfied that no other adequate remedy is provided by law on the application of an aggrieved person, make an order declaring that an act done or proceeding taken, two things, act done or proceeding taken within the territorial jurisdiction of the court by a person performing functions in connection with the affairs of the Federation, a province or a local authority has been done or taken without lawful authority and is of no legal effect. So there are two other things we need to discuss: without lawful authority and of no legal effect. So without lawful authority has been further emphasized through no legal effect. Now the act done, that means the action has been completed, decision has been taken. The other word used is proceeding taken, which means prescribed course of action for enforcing a legal right. Proceedings include every step taken towards further progress of the cause by a court or tribunal. Proceeding commences when machinery of law is set in motion and it continues till it is finally decided or concluded. Now the two other terms, without lawful authority and of no legal effect, I'll be explaining. Without lawful authority means beyond one's power conferred under the law, authority used which is not lawful. For example, there is a case which is to be dealt with by a rent tribunal constituted under the Cantonment Rent Restriction Act 1963, and it is dealt by civil court. So that we will say that court had no jurisdiction and the decision rendered by the court, if any, is without lawful authority, it was beyond the power of civil court to decide that. It is in its dictionary sense, the word lawful means according to law, not contrary to law, permitted by law, sanctioned or recognized by law. Thus, if law has nothing to do against a thing, then it is not contrary to law to do it. Now, the expression without lawful authority and of no legal effect, they have been dealt extraneously in the judgment of Muhammad Hussein's case, BLD 1974, Supreme Court 139, as expressions of art and refer to jurisdictional defects, distinguishable from the erroneous decision, whether on question of fact or sometimes on question of law. The other term is used, acted lawfully, means within the powers conferred on a person by law. If someone is acted outside the powers conferred by law, would mean that he had acted without lawful authority, or when he exceeds his power, it would also mean without lawful authority. Now, the authority means a legal power one enjoys or right power derived by virtue of office or through some statute, etc. This was described in detail in the case of Begum Agha Shorish Kashmiri's case, PLD 1969, Supreme Court, page 14. It dealt with the Constitution of 1962, and their Article 98 was of similar nature. And court came to the conclusion that the person, the husband of this lady, was detained by the government has no authority to detain it. So the government was acted, the concerned officer acted without lawful authority, so it was the action was struck down. Now, without lawful authority, writing it would have been enough, but the framers of the Constitution went step ahead by incorporating the word no legal effect. So it has been further emphasized by using the word no legal effect in addition to word without lawful authority. No legal effect means it's a nullity or something done by someone which has no existence in law. And any authority if needed on this no legal effect, it is PLD 1966, Supreme Court, page 1, by Justice Kekaus in Jamal Shah's case. Now, in writ of certiorari, when you come to the court, you question the action of a government, or in most of the cases, actions of a tribunal or court of law, where no other remedy is provided under the law. So, while filing the writ of certiorari, you have to be very conscious in impleading the government functionary and the court itself, not by its name, but by the civil court, the rent controller, additional district judge. And the sequence should be, there are two Supreme Court judgments on the point. Probably it's PLD 1981, Supreme Court 522, that don't implead an additional district judge or civil judge as respondent number 1. It will give a bad impression calling his name in the court. So implead him after all other parties in the end. For example, if the additional district judge implead him as respondent number 7 and the civil judge is to be implead him in sequence as respondent number 8, don't implead him as a respondent number 1. There is a clear restriction on this by the Honorable Supreme Court, which has not been followed. Now, while issuing writ of certiorari, high courts normally show caution and rarely interfere. And this must be kept in mind that writ of certiorari is not a second appeal or a second revision. When the High Court takes up a petition under Article 199 or takes up a petition under Section 115 of CPC, it is working in altogether different spheres. The scope of interference while taking up a writ of certiorari is altogether different because finality is attached to the orders. If a revision has been decided, law doesn't provide for a second revision. You cannot come to the High Court and ask for a second revision. You have to come within the certain parameters that have been settled and bring your case to those parameters. Only then you can succeed or getting a notice from the High Court. Otherwise, it will be dismissed in limine. So the court exercising writ of certiorari acts in the exercise of supervisory and not the appellate jurisdiction. The scope of interference by High Court is limited to the inquiry as to whether the tribunal or authority has acted in accordance with law. Finality is attached to decisions of appellate and revisional courts. Like no second appeal or revision in family matters is provided, and we see every day that writs are filed to challenge the decision on the appellate side of a family court. or 12(2) application is filed before the court, accepted or rejected, you go to revision. Revision is accepted or refused, you come to the High Court in constitutional jurisdiction under writ of certiorari. So there has to be certain parameters that has to be followed, and you cannot ask the High Court to act as a court of appeal or revision once again. So you have to bring your case within the exception that has been settled by the court. For example, no factual controversy can be asked to be considered by the High Court. And very recently, the Supreme Court in family matters has shut the doors that factual controversy cannot be considered while dealing in family matters. And you can only ask the court for some relief if the court has acted without jurisdiction or the act is without local authority. The two recent judgments on the point are 2023 SCMR page 413 and the other one is 2023 SCMR page 1434. So you have to bring the case in exceptions provided in those judgments, which is very rare. And also the exceptions provided in other judgments where the criteria has been settled that what are the exceptional circumstances where High Court would interfere. There has to be a decision which is against the express provision of law or some patent illegality committed by the lower forum, only then the High Court would interfere, otherwise it would not. So it will be a fruitless exercise to go into and discuss the evidence instead of going into what the High Court wants you to highlight in the petitions. Now, there are certain exceptions. Even order passed by the revisional court can be set aside by High Court only if the court has decided something which is absolutely against law. One such example is Elias Began's case, PLD 2013, Supreme Court 255. In that case, number of opportunities were granted to defendant to lead evidence, and after availing number of opportunities, including one final opportunity, they came up with an application to lead additional evidence. Application was turned down by the trial court. Party goes to revision. Revisional court accepted that application on the ground that it will be too technical to knock out that person. So instead of referring to the relevant law order 13, the court accepted the revision petition. Matter went to the High Court. High Court said no, you have to confine yourself to within the law, and you have to perform all what is required by law to do. And you cannot say that it is just merely technicality. So the High Court turned down the writ petition. Matter went to Supreme Court. Then Supreme Court elaborately settled the principles under which the High Court set aside the order of the revisional court. So matter went to Supreme Court. The High Court said that High Court was justified to set aside the order passed on revisional side because that order was patently illegal and it was against the express provision of law. If such is the case, then High Court would not shut its eyes and let the illegality to continue. It will set aside the order. So in such circumstances, the High Court can interfere. The basic judgment on the point where the High Court can interfere to set aside the revisional order is PLD 1973 Supreme Court, page 24. Now, so far as criminal matters are concerned, if the revision is dismissed, party comes to the High Court under Article 199 seeking order of the revisional court to be set aside and reappraise everything. So that matter was decided 3 decades ago, and it is said that if the criminal revision is dismissed, the High Court has no jurisdiction to set aside the order passed by a criminal court on revisional side. It is the only exception is if it was absolutely illegal or against the express provision of law. There are 3 judgments on the point which settled this issue. First was PLD 1981 Supreme Court 522. Second was PLD 1993 Supreme Court 399. And lastly, 2010 SCMR page 105, in which there was an order passed under section 145, elaborate inquiry conducted by magistrate, order upheld in revision. High Court interfered. The Supreme Court said no, High Court has no jurisdiction to interfere in concurrent findings, and matter finally settled by a criminal court on revisional side. Now, a distinction has to be made between a wrong decision and a decision without lawful authority. So this is often confused. A tribunal having jurisdiction can decide the matter rightly or wrongly. It does not confer the power on the High Court to set aside a wrong decision, because the penalty is attained to the decisions. Mere fact the decision is incorrect doesn't render it without jurisdiction. Grant of relief under constitutional jurisdiction of High Court is meant to foster the administration of justice and turn down orders which were unlawful, arbitrary, capricious, or suffering from misreading of record. So, certiorari jurisdiction is based on the principle that whenever judicial jurisdiction is exercised by inferior court or tribunal resulting in abuse of process of law or excess of jurisdiction, it is liable to be corrected by High Court. The purpose is that High Court is liable for keeping inferior courts or tribunals exercising judicial powers within the limits of their jurisdiction. It is manifest from the above that through a writ of certiorari, a High Court is empowered to correct the errors committed by the inferior courts or tribunals, and on the basis of other hand, to annul the acts or proceedings taken by the inferior bodies without any lawful authority. It can check any decision or orders passed by the court or act of government brought to its notice through application of an aggrieved person. As regards the character and scope of certiorari, it will be issued for correcting the errors of jurisdiction. In order to conclude what writ of certiorari more precisely, it can be said that writ of certiorari can be issued in the following circumstances. 1. Where an inferior court or tribunal acts without jurisdiction or in excess of it or fails to exercise it. That means it goes against the statute or against the express provision of law. Secondly, when the court or tribunal acts illegally in the exercise of its undoubted jurisdiction, as when it decides without giving an opportunity of hearing to the parties or violates the principles of natural justice. In that circumstances too, the writ can be issued. Thus, the High Court is empowered to interfere in all cases of excess of jurisdiction, whether the person exceeding jurisdiction is a court, a judicial or quasi-judicial body, or purely executive administrative tribunal or officer, provided such body, authority, or officer is performing functions in connection with the affairs of the Federation, a province, or a local authority. It is tried law that a writ of certiorari cannot be issued as a substitute of appeal or revision, as its scope is limited and circumscribed to the eventualities mentioned above that I have highlighted. So we have covered three types of writs: mandamus, prohibition, and certiorari. These three writs are only to be filed if a person is aggrieved. Now we are coming to two different types of writ in which any person can file the writ, that is habeas corpus, which means you may have the body or to produce a body or have his body mend or remedy the illegal detention. Article 199b Roman 1 deals with this, which reads, on the application of any person make an order directing that a person in custody within territorial jurisdiction of the court be brought before it, so that the court may satisfy itself that he is not being held in custody without lawful authority or is in an unlawful manner. It is issued to produce a person who has been detained unlawfully, illegally, or wrongly, whether in private custody or prison or by an institution. So when the High Court takes up a matter, issue a notice, it is called process is issued for production of a person illegally detained to be brought before the High Court, and the High Court will ask the authority who is bringing it that under what authority, under what provision of law you have detained such and such person. Although basic and fundamental human rights and their safeguards are enshrined in and guaranteed by the Constitution, number 1, to enjoy protection of law and to be treated in accordance with law, it is an inalienable right of every citizen in terms of Article 4 of the Constitution. No person shall be deprived of life and liberty save in accordance with law under Article 9. Freedom of movement, freedom of speech, these are our fundamental rights guaranteed by the Constitution. The writ of habeas corpus is used to secure the release of a person who has been detained unlawfully or without lawful jurisdiction or lawful justification. The article provides a process by which a person who is confined without legal justification may secure a release from his confinement. An application is made supported by affidavit. If prima facie grounds are shown, the court directs that notice of motion be given to produce the retinue to be produced on a day fixed, and if no explanation is offered, the retinue is set at liberty. In Pakistan, there is no codified law of habeas corpus. Nonetheless, provisions are pari materia and akin to Section 491 of CRPC. The empowerment of Sessions Court to exercise this jurisdiction was welcomed and provided quicker relief and less expensive remedy, and it also burdened the load that was on the High Courts. It was shared. So this is basically the habeas corpus. The last one is writ of quo warranto. That also can be filed by any person. Quo warranto means under what authority? Article 199 clause 1b Roman 2 deals with it, which reads, on application of any person requiring a person within the territorial jurisdiction of the court holding or purporting to hold a public office to show under what authority of law he claims to hold that office. So any person can file a petition before the High Court challenging appointment of any person, that under what authority, under what law he is holding that office. And while drafting a writ of quo warranto, you have to be very cautious to write clearly that what are the shortcomings which you are challenging, and you are saying, and you have to persuade the court that that person is not entitled to hold the office. So in a writ of quo warranto, the laches is not applicable. It is not a hurdle because it is a continuing wrong. As long as that person is holding an office, it is a continuing wrong. The power conferred upon the High Court by this clause is to require a person holding or purporting to hold public office to show under what authority he claims to hold that office. Eligibility and competence of a person to hold public office or a post can be questioned, and court can ask under what authority he or she is holding such office. Court will examine and determine if he is qualified to be appointed. If not, court will declare such person is not entitled to hold the office and shall ask him to leave the office. The remedy under clause 1, subclause B2 of article 199 is available only against a person holding or purporting to hold public office. That is the requirement, and it is not available against holder of a private office. The expression public office is not defined in 1973 Constitution. It was though defined in 1962 Constitution to include any office in service of Pakistan and membership of an assembly. The definition was not exhaustive, and in any case, connotation of the expression public office is well known, and that perhaps explains the absence of definition from 1973 Constitution. The definition of term public office has been adopted by the courts in Pakistan in view of law laid down in the case of Masood al-Hassan versus Khadim Hussain, PLD 1963, Supreme Court 203, as an office created by the state by character or by statute when the duties attached to the office are of public nature. This was reiterated in the case reported in PLD 1974, Supreme Court 228. Now, when a person brings a writ of quo warranto, the burden is entirely upon the relator. Relator is called the person who brings the writ of quo warranto to show that respondent has no right to hold the office. And this has been emphasized in PLD 1963, Supreme Court 203. The criteria of this type of writ was also settled in the case of Muhammad Khan versus Lahore Cantonment Board, PLD 1964, Lahore, page 1 to 5, under 1962 Constitution, wherein it was held, and I quote, a proceeding for a writ of quo warranto is initiated to test the validity of an appointment to a public office, and a petitioner does not seek to enforce any right of his as such, nor does he complain of non-performance of any duty towards him. What is in question is the right of the respondent to hold a office of public nature, and I unquote. Now, credentials of relator are very important, and it must not be based on mala fide. There are two tests, not based on mala fide, or he should not have a personal interest. If he comes to the court with a writ of quo warranto that he is not liable to be appointed, let me appoint to this job. The writ will be thrown away straight away because he should not have a personal interest. For this, there are two judgments. If you kindly note, PLD 2018 Supreme Court 114, that is regarding the credential of relators, and the other judgment is 2004 SCMR page 1299. Now, the jurisdiction exercised by the High Court is inquisitorial in nature and not adversarial like other writs, And for this, it was explained in 2013 SCMR page 1035. And judgment on the point that he must not have some personal interest is 2019 PLC CS page is 1050. So these were the 5 kinds of writs. Now clause 5 deals with the person against whom the writ can be issued. The grievance of an aggrieved person should be against a person who is performing functions within the territorial jurisdiction of the High Court in connection with affairs of the federal government or provincial government or local authority. The High Court may direct such person to refrain from doing such act he is not allowed to do by law, and may also direct a person to do something he is required by law to do, which person is not doing or avoiding to do. A writ can be filed only against the state, and it is not maintainable against private individuals or corporations which are not controlled by the government. Now, state has been defined in Article 7, which reads, in this part, unless the context otherwise requires, the state means the federal government, Majlis-e-Shura of Parliament, a provincial government, a provincial assembly, and such local or other authorities in Pakistan as by law are empowered to impose any tax or tax. Now, the functional test that whether against a corporation or a bank or any other institution the writ is competent is called, it is enumerated in 2013 SCMR 1383 in Abdul Wahid versus HPL, that there has to be a functional test, and the functional test is the 2 criteria are to be fulfilled. One is, what is the extent of the state in that institution or corporation, and the dominant or administrative control of that department. These are the 2 tests which are, if they cross the threshold of these 2 tests, and if there is financial interest is secured by the government, or the government has mostly the dominant and controlling effect of that institution against that institution, be it a bank or other corporation, writ can be issued. Now, coming to the last leg of my topic, procedure, practice, principles, and court fee that is to be levied on the writ. So, if a person comes to you and says that I want to file a writ, so there are certain things the lawyer need to examine first before going to High Court and filing a writ. First, you have to see whether the writ is maintainable, whether it comes within those 5 categories that have been mentioned. If any one of the categories is attracted or not, then the next question to be examined by the lawyer is whether filing a writ in Rawalpindi bench, I have the territorial jurisdiction. It can be filed here or it to be filed in Lahore or Multan. So the Article 198 is to be examined. Then against a person you are filing a writ, you have to examine whether it is a person who comes within clause 5 of the Constitution, Article 199 of the Constitution, and against that person writ will be competent, or I will be facing an embarrassing situation when I will put a question that how the writ is competent against such and such person. That has to be examined. And then, most importantly, the difficulties being faced these days by the lawyers, that you are asked what type of writ you have filed. So if you examine this before filing of the writ, and instead of writing under Article 199 of the Constitution, write under Article 199 1A of the Constitution, write under Article 1 subclause 1B, then it will be clear to the court that in which jurisdiction he is asking me to issue the writ. So this is very important that while drafting it, mention that article. It's not very difficult. Now, the procedure to be followed by the court is that you file an urgency application. The matter is taken up on the following day. So, at the preliminary stage, all these questions are mostly put to the lawyer, and if he crosses that stage and the writ is maintainable, like filed against a proper person, grounded properly, then at the preliminary hearing, the notices are issued. And upon a question is being put that I have already mentioned that what procedure or what law would be applicable, this procedure to be regulated, the writ is CPC under PLD 1970 Supreme Court page 1, which is the basic judgment. So, once the notice is issued, there are 2 situations. One is either the High Court would issue a simple notice to the party. The other party can file a comment, or if it is not asked, it can come at a preliminary stage and explain the wrong complaint of Now there is another situation which is very important where the substantial question is raised and the High Court admits the writ to a regular hearing. In that case, if the writ is admitted to regular hearing, you have to file written statement. And if you don't file a written statement, like in CPC, in civil suit, if you don't file a written statement, the law is that contents of the writ petition will be taken as true as it is if you fail to file a written statement. So this was settled in the cases of Nazir Ahmad Sabri versus MBR 2003 SC YLR 861, and the other is Mehboob Saber's case 2003 MLD 1361. And these were the writs under even the certiorari writs. Even then, you have to file a written statement to controvert what has been stated in the writ petition. Now, next comes the question that what is the period provided for filing a writ petition? There is no period provided under the law. Writ petition can be filed at any time within a reasonable time. So, what is the reasonable time has been mentioned in various judgments as 3 months and not more than 4 months. So if a writ petition is filed beyond that period, then it would be said that writ petition is hit by laches. The person has been sleeping over his right and he has come to the court with a delay. So on ground of laches, the request can be turned down. Now, so far as laches is concerned, it is not a principle of universal application. And there are certain exceptions where the writs are issued if the cause of action is recurring one, like payment of salaries or some allowances, etc., or the action complained of is so illegal that High Court, exercising its discretion, the word may I use in the Article 199, can still issue the writ. So if judgments on the laches, the recurring cause of action, 2 judgments, PLD 2013 Supreme Court 268 and 2020 PLC CS 668. After a considerable delay, the writ was issued. The Supreme Court said it's fine because the action complained of was patently illegal and wrong. Now, there can be cases where facts justified issuance of writ, even if it is filed with delay. There is a case in which 2 years delay, and even then the writ was issued and endorsed by the Supreme Court, 2021 SCMR 1313 and 2009 SCMR 177. In another case, 2005 SCMR 126, a writ was issued, which was filed with a delay of 1 year, because the court held that equity leans in favor of the litigant, and it would be very unjust to dismiss the writ on the question of laches. So what has been settled is that this cannot be decided on the basis of laches alone, and court has to examine each and every aspect of the case. And a writ was issued with a delay of 5 years even in 2004 SCMR page 400, because the circumstances justified this. Now, while exercising the jurisdiction, the notice is issued, written statement is filed, the parties come before the court, the High Court would examine case finally and would come to a definite conclusion that action complained of justifies issues of writ or not. Now, in doing so, there are certain limitations of the High Court. The High Court cannot substitute its finding with that of the lower forum, merely because on reappraisal of evidence, High Court comes to a different conclusion. There is restriction on it, no writ can be issued to substitute the findings of a lower forum, because this is an extraordinary remedy exercised by the High Court in aid of justice. Now, there are cases where public interest litigation is brought before the court and numbers of petitions are filed on public interest. Still, you have to just cross the hurdle of if you are an aggrieved person or not, or your writ comes within the exception, no aggrieved person. So, this criteria was settled by the Supreme Court in Imrana Tiwana's case, 2015 SCMR 1739. Then there are certain restrictions on High Court not to issue a writ which relates to terms and conditions of a service. There is a bar, and the basic judgment is 2007 SCMR page 54, that anything relating to service matter, writ cannot be issued. Then there are certain exceptions, eligibility or other things, fitness, that is a different topic. Then the High Court cannot exercise suo motu jurisdiction, and only a matter that has been brought before the High Court has to remain within that sphere and cannot grant a prayer which is not there. So the suo motu powers exercised by the High Court are discouraged, and it has been termed as judicial overreaching. This is in the PLD 2021 Supreme Court 571 and 2018 SCMR page 414. So, what I have highlighted in drafting the writ petition, utmost care has to be exercised. It has to be very simple drafting. The grounds should be with precision. Bring it within the provision, the type of writ you are filing. Take the grounds that those parameters settled in Article 199, those are justified. And if there is some case law precedent on the point, settled point, you may refer that judgment in your grounds. So the more precise and more to the point it will be, the judge reading the file a day before should not get, there's no end to it, he should not get lost in that file, but if it is crisp and to the point pertaining to the law, then it will be easy for the High Court to grant you relief instead of asking a number of questions on the following day. And similarly, the prayer, that must be also in accordance with the requirement of Article 199, that if you are filing, you may pray that it is therefore respectfully prayed that order dated such and such may kindly be declared as illegal and without lawful authority, and same may be set aside. If this is the prayer, that it will be very precise and to the point, bringing it to the type of writ you are filing. Now, lastly, I'll be addressing on court fee leviable on the writ. The court fee was ordered to be levied in subcontinent for the first time in the year 1780 by Viceroy Warren during East India Company's rule over India. Court fees Act was promulgated in 1870. However, the British rulers exempted the High Courts, Supreme Court, established in the three presidency towns of India, namely Calcutta, Madras, and Bombay, where their British subjects could file a suit without paying any court fee. After creation of Pakistan, the laws then in force in British India were adopted. The Court Fees Act 1870 is one such law, which remained in force in Pakistan in terms of Article 268 of the Constitution of 1973 as existing law and has been protected. Now, Article 202 of the Constitution empowers the High Court to make rules for regulating the practice and procedure of the court or any subordinate court to the subject to the Constitution. Article 202 reads, subject to the Constitution and law, a High Court may make rules regulating the practice and procedure of the court or to any court subordinate to it. In pursuance of the above provision of the Constitution, Lahore High Court framed certain rules from time to time for regulating its procedure. In order to determine the leviability of court fee on writ petitions, relevant rules and orders of the Lahore High Court are to be seen, and the relevant is volume 5 relating to procedure of High Court, chapter 1, judicial business, part A, rule 11, which states no petition, memorandum of appeal or document which ought to bear a stamp under the Court Fee Act 1870 shall be received in the court until it is properly stamped. And rule 10, Roman 1, chapter 4F, part 3 of part J, volume 5 of High Court Root and Address is the direct rule which deals with the leviable of 500 rupees on the court fees, which reads, a court fee of rupees 500 shall be payable on each petition, but no court fee shall be required in case it is required in respect of a detention of a person or under orders of any public authority. In Pakistan, in the case of Defence Housing Authority versus Lieutenant Colonel Syed Jawad Ahmed 2013 SCMR 1707, the Supreme Court defined public authority, which reads, a public authority is a body which has public or statutory duty to perform and which performs those duties and carries out its transactions for the benefit of the public and not for a private gain or profit. So section 19, it provides an exemption if a person is detained or is behind bars in terms of his clause 17. Now, there are cases that if there are number of petitioners, whether you have to give court fee of 500 rupees or for each petitioner you have to give court fee separately. These two situations were considered by the Honorable High Court in two different different judgments. One is Abid Hussain Shah's case PhD 2012 Lahore, page 334, and the other case PhD 2007 Lahore 461, in which it was held. From the survey of above case law, it can be safely concluded that each petitioner in a joint petition has his own cause of action, and relief claimed by such petitioner is to his extent, and grievance of such petitioner is individual. The petition by each one of the petitioner is a joint petition, shall be deemed independent, and each of such persons shall be liable to pay the court fee separately. But there can be situation where the writ of certiorari is filed and there are a number of parties, but one order is challenged. There you are not required to file court fee for each one of the petitioners, because that is something different and their rights cannot be separated. So I conclude my lecture with that powers under 199 should be daringly exercised in appropriate cases, and it has great impact on the relationship between the masses and the state. And in case when action is found unwarranted, exemplary court should also be imposed, because with the name justice used with the judges of the High Court, justice means to find the ways and means to give justice to the public, not to curtail. And before concluding, a few words about the writs by Mr. Justice M.R. Kiani, former Chief Justice of West Pakistan High Court, who was a great admirer of writ jurisdiction. While addressing Sindh High Court Bar Association on 11th of December 1958, emphasizing the importance of this jurisdiction, said, "Mandamus and certiorari are flowers of paradise, and whole length and breadth of Pakistan is not wide enough to contain their perfume." And further stated, "God fulfills himself in many ways, and that we, the judges, are the humble instruments of his fulfillment. Writ jurisdiction in the modern manifestation of God's pleasure, and the God pleasures develop in the High Court." These are my submissions. Hope you have understood. And I'm very thankful for all of you for this patient hearing and listening.
How can we get copy of this note, please?
You can send me a message and I can share soft copy with you. Or you can get it through the Thank you, sir.
कोई क्वेश्चन अगर हो, वैसे तो आगा साहब ने बड़ा तारो और राष्ट्र में लिख दिए, और कुछ नोट्स जो हैं वो हम
ये मैं शेयर कर लेता हूँ। अगर मुझे व्हाट्सएप मैसेज करेंगे मैं सॉफ्ट कॉपी आपको
बहुत बहुत शुक्रिया आगा साहब। मैं जहाँ पे आप सबका शुक्रगुजार हूँ कि आपने इस गर्मी के माहौल में बड़ी तादाद में इस लेक्चर में पार्टिसिपेट किया। वहाँ पे शुक्रगुजार हूँ आगा मोहम्मद अली साहब का, जिन्होंने इंतहाई दिलजमी के साथ और अपनी मायराना और जो इनकी प्रैक्टिस के नुकात थे उन्होंने सम अप किया। बहुत लेंथी टॉपिक्स थे, लेकिन माशाल्लाह उन्होंने एक अपनी जो इनकी रिवायती स्पीड है उसके साथ लेक्चर दिया। मे भी आपके लिए कुछ चीज़ें होती हैं, क्योंकि प्रोफेशनल लॉयर्स जो होते हैं वो प्रोफेशनल सच टीचर नहीं होते, लेकिन क्योंकि ये लेक्चर्स किसी लिए सिर्फ और सिर्फ नॉलेज शेयरिंग की है, सारों का बेसिक लेवल तो LLB है, लेकिन जो तजर्बे और एक्सपीरियंस का है फ़र्क, उसको शेयर करने के लिए ये क्लासेस जो हैं वो अरेंज की गई हैं। और मेन मकसद ये है कि हम अपने यंग लॉर्ड को या अपने लॉयर ब्रदर एंड सिस्टर को हाई कोर्ट में पेश होने के लिए वो बेसिक ग्रूमिंग दे दें, जिसकी वजह से हमारे रावलपिंडी बार एसोसिएशन मशहूर की है कि ये प्रोफेशनल लॉयर्स इसने बनाए हैं। और पूरे न सिर्फ पंजाब के अंदर आपके लॉयर्स और जजेस का नाम है, बल्कि पाकिस्तान के अंदर हमारे जो पिंडी डिवीजन के लॉयर्स हैं उनका एक मुनफरिद नाम है। तो हमारी कोशिश है कि ये पॉजिटिविटी जो बार की तरफ से एक ड्यूटी भी है वो हम ऐसा तरीके से कर भी सकें। मैं इन लेक्चर सीरीज़ में जो मेरे साथ टीम है, मलिक जवाद खालिद साहब जो हेड कर रहे हैं, और मेरे साथ कोऑर्डिनेटर है मैडम नस्मा अब्बासी, और जो हमारी जॉइंट सेक्रेटरी हैं, एडिशनल सेक्रेटरी सुमेरा यूसुफ साहबा हैं, और इसके अलावा हमारी पूरी जो कैबिनेट है वो इस लेक्चर को अरेंज करने में हेल्पिंग है। और यासर खान गुजर साहब का नाम मैं इसलिए लेता हूँ कि वो हर तरह के मुझे हेल्प करते हैं, इवन ऑर्गेनाइजेशन से लेके और आखिर इसकी जो रिपोर्टिंग होती है वेब के ऊपर वो करते हैं। आप सबकी सहूलत के लिए ये आज का लेक्चर क्योंकि آن لائن نہیں ہو سکا، لیکن ہم نے لیکچر ریکارڈ کیا ہے اور لیکچر سیریز کا ایک ہم نے ویب پیج بنایا ہوا ہے واٹس ایپ کے اوپر، اس میں ہم کوشش کریں گے کہ یہ شام تک اس کو اپلوڈ کر دیں گے. باقی یہ لیکچرز کا جو سلسلہ ہے وہ کل بھی انشاءاللہ اپنے ٹائم کے ساتھ، کیونکہ ابھی میں نے اسکیجول چیک کیا ہے واپٹا والوں کا کل بجلی ہے، تو اس لیے کوشش ہماری یہ ہوگی کہ 11 بجے ہم یہاں پہ اکٹھے ہوں اور اس کے مطابق 10-12-15 منٹس کا جو ہوگا ارینجمنٹ ٹائم ہم کوشش کریں گے 11:15 بجے ہم اسٹارٹ کریں اور 12:30 بجے تک ہم جوائن کریں. میں انتہائی شکر گزار ہوں اپنے مرزا انور بیگ اکیڈمی کا کہ جنہوں نے یہ لیکچر سیریز ارینج کی، اور میں آپ سب سے بھی اس کا بیک اپ لوں گا کہ اس میں کوئی کمی ہوتا ہی کوئی اس طرح کا اگر کوئی مٹیریل جو ہے جس کوئی آپ کی ریکوائرمنٹ ہو اور وہ ہم پرووائڈ نہ کر سکیں. 3 سے 4 ٹاپکس دیے جاتے ہیں، ٹائم شارٹ ہوتا ہے، تو اگر کوئی بندہ اس میں سیٹسفائی نہیں ہوتا تو دین ہم کوشش کر رہے ہیں کہ آن لائن لیکچر بھی وہ سن لے اور مٹیریل بھی اس کو دے دیا جائے گا. بہت بہت شکریہ. میں مزید آپ جو ہے بڑے صبر کے ساتھ بیٹھے ہوئے ہیں، آپ پسینہ پسینہ ہوئے ہوئے ہیں، تو میں آپ کو دعوت دیتا ہوں، چھوٹی موٹی ضیافت ہے ہماری طرف سے قبول فرمائیے گا. بہت شکریہ آپ کی آمد پر.